The hearing opens with every sign that this divorce has already been solved outside the courtroom, which immediately changes the judge's role. Instead of deciding who deserves what, the court becomes a checkpoint to verify that both parties actually understand what they agreed to. That distinction matters because judges are cautious whenever a settlement replaces litigation.
All right, go on the record in Thompson versus Thompson, this is file number 2615021. The record should reflect that Mr. Phelps is present here in the courtroom with his clients. I see Ms. Thompson's connected by Zoom along with her attorney, Mr. Elhart. I have this set as a date for a final hearing. Mr. Phelps, on behalf of, is that how you might proceed today?
Your Honor, we have reached an agreement. There is a judgment circulating, but it has not been signed yet. We're certainly prepared to present and have the court take the proofs and preserve them if Your Honor is so inclined.
Any objection, Mr. Elhart?
None at all, Your Honor.
Mr. Thompson, can you raise your right hand, please? Do you solemnly swear or affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth to help you God?
I do, sir.
Thank you. You can lower your hand. Mr. Elhart, are you going to be taking any testimony from your client today?
Yes, Your Honor. Thank you.
Ms. Thompson, can you raise your right hand, please? Do you solemnly swear or affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth to help you God?
Yes, I do.
Thank you. You can lower your hand. Mr. Phelps, I'll have you go first. Please proceed.
Thank you, Your Honor. John, would you state your full name for the record, please?
John Dennis Thompson.
And are you the plaintiff in the Kalkaska County divorce action, John Dennis Thompson v. Renee Denise Thompson, filed on or about February 2nd, 2026?
Why is there on this? Okay, yes, I am.
All right.
I'm trying to read.
Yeah, and at the time that you filed your complaint for divorce, were you a resident of the state of Michigan for more than 180 days?
Yes, sir.
And a resident of Kalkaska County for more than 10 days?
Yes.
Is it true that you and Mrs. Thompson were married on July 31st, 2023 by an officiant legally authorized to perform marriages in the village of Kalkaska?
Yes.
To the best of your knowledge, Ms. Thompson is not currently pregnant, correct?
No, she's not pregnant.
All right. And you folks had no children during the
No
marriage?
children.
All right. In your complaint, you allege that there has been a breakdown in the marriage relationship to the extent that the objects of matrimony have been destroyed and that there remains no reasonable likelihood that the marriage can be preserved.
Right.
Was that statement true when you filed your complaint?
True.
Does it remain true today?
It's true today too, sir.
All right. The complaint also indicates that you folks have accumulated some personal property during your marriage. Is that an accurate statement?
Yes.
We've also exchanged with Mr. Elhart various settlement proposals. Those settlement proposals have been reduced to writing in a proposed consent judgment of divorce, a copy of which is in front of you.
Yes.
Have you seen the proposed judgment, read it, and do you understand its terms?
Yes.
Does it fully and accurately reflect the property settlement between you and Ms. Thompson?
Yes.
Just a couple of key points on that settlement. In paragraph 3.11, there's an indication that upon entry of judgment, you will pay the sum of $20,000 to Renee Thompson.
Yes.
Is that correct? All right. In paragraph 3.1.2 lists 9 items of personal property, including a 2021 Hyundai Kona 4-door vehicle and things like a bed, a bicycle, a computer, and those sorts of things. Is that reflective of your agreement with Ms. Thompson?
Yes.
And you affirm that she will receive those things once judgment is entered, right?
Yes.
All right. You own real property on Supply Road southwest to South Boardman, Michigan. That property is titled in your name only, correct?
Yes.
And the two of you have agreed that that will remain in your name, right?
Yes.
All right. Judgment also awards vehicles, certain bank accounts, and has the statutory language regarding insurance and retirement benefits. Do you understand those terms as they are written? Do all of those terms reflect your settlement with Ms. Thompson?
Yes.
The judgment also indicates that neither of you will be awarded any spousal support, whether periodic or in gross, and that the same is forever barred as to each of you, and that each of you to have waived the right to spousal support with knowledge and voluntarily, correct?
Correct.
Have I left out anything in terms of your settlement with Ms. Thompson?
We have a phone together. Did I pay for everything? I told her, I'd give her 2 weeks and I'll cut the phone off.
Okay,
Give her 2 weeks to get a phone.
let me ask the question a little bit differently. Does the judgment reflect the agreement you have with Ms. Thompson about division of the personal property acquired during the marriage?
I don't think so.
The
I
entire
think-
hearing changes the moment dissatisfaction replaces certainty. Until then, the proceeding moves like a routine, uncontested divorce. Suddenly, hesitation introduces legal risk because a settlement cannot rest on uncertainty. The issue isn't whether someone wishes they had received more money. Nearly everyone leaving a negotiation believes they could have done better.
So, okay, I think everything we wrote down and agreed on is what we both agreed.
Okay, so you just said, I don't think so. I think you meant to say that the judgment is accurate.
Okay, judgment's accurate.
Thank you.
I'm sorry, I'm old school and I don't know the big names.
It's okay. We just want to make sure that everybody's clear here. So once you and I have signed, Mr. Elhart and Ms. Thompson have signed, the judgment will be presented to Judge Mertz. Judge
Okay.
Mertz will sign it. It will be entered in the court file by the court clerk. At that point, your divorce is final and binding.
Okay,
You understand that you can't come back here and ask the court to change the terms of the settlement.
yes, I understand.
There are a few limited exceptions in law, but very
No.
rare cases. All right.
No,
Is it
no
your,
need for
is it your request to the judge that when presented with the judgment, he signs it and finalizes your divorce?
it. Yes.
Thank you, Your Honor. Nothing further from Mr. Thompson.
Mr. Elhart, do you have any questions for Mr. Thompson?
No, Your Honor, thank you.
Okay, please proceed if you have questions for your client.
Thank you. Ms. Thompson, you've heard the settlement that's been placed on the record, is that correct?
Yes, I've heard it.
And we've gone back and forth on that, and we've talked about numbers one way or the other, and eventually you've decided to proceed ahead on this settlement, is that correct?
I'm just not happy with the amount I'm getting.
So are you saying that you're not happy to go ahead with the settlement?
That's right.
So you prefer so you don't have an agreement, is that what you're saying today?
Well, I guess I can settle.
Well, you don't have to guess. This is a termination of a marriage, and you've got to make certain that this is what it is. We've talked at length about the cost benefit analysis and going ahead and how much it might cost you for an additional $5,000. Is that correct?
I think so.
Well, you wanted 25, he's offered 20, and that's the difference, correct?
Yes.
All right. And at the end of the day, there's a cost in going ahead with litigation, cost of attorney fees, that sort of thing. And at this point, you told me that you'd agreed to the 20,000. Is that correct?
Yes, that was correct.
All right. And is that something that you agreed to today?
Yes, it's fine.
And this is a final divorce settlement. You've heard Mr. Phelps' indication of that on the record. That's all you're this is the end. Is that correct?
Yes, it is.
Right. And you're sad about that. I get that. Is that right? Right. Thank you, Your Honor. Have you been satisfied with my representation so far, ma'am?
Yes, I have, Craig. I'm sorry.
That's all right. Thank you very much, Your Honor. I have nothing further.
Phelps, do you have any questions for Ms. Thompson?
No, Your Honor. Thank you.
All right. The court finds that the statutory grounds for divorce have been met by the testimony of the parties. The court will grant the divorce. I will look for presentation of that judgment. Once that's presented to the court, we'll sign it. The court will not schedule any further hearings in this matter in light of the proofs today. Mr. Phelps, anything further from the record on your side?
Nothing. Thank you for your time, Your Honor.
Mr. Elhart?
Nothing. Thank you, Your Honor.
Thank you. That's all for this hearing today. And Mr. Elhart, you and your client are free to disconnect. Mr. Phelps, you're free to leave.
Thank you, Your Honor.
Thank you, sir.
Thank you.
The final ruling sounds brief, but it reflects everything established earlier in the hearing. The judge grants the divorce only after confirming that statutory requirements, sworn testimony, and mutual consent all support the written judgment. Nothing dramatic happens because the difficult work occurred during verification, not during the ruling itself. This demonstrates how experienced judges manage uncontested cases. They front-load the careful questioning so the final decision becomes almost inevitable. By declining additional hearings, the court also signals confidence that no unresolved legal issue remains. Closure in family court is rarely created by one sentence. It's earned through a complete record that leaves very little room for future challenges. The commentary after the hearing raises a question that viewers naturally ask whenever emotion appears during financial negotiations. Was the reaction driven by money, the relationship, or both? The transcript alone cannot answer that with certainty, and that's exactly why courtroom appearances can be misleading. Stress, embarrassment, disappointment, and grief often overlap during divorce proceedings. A single emotional moment doesn't reliably reveal someone's true motivation. Courts recognize this limitation, which is why judges rely on sworn answers rather than assumptions about facial expressions or tears. Legal decisions are built on confirmed testimony, not personal interpretations of emotion, because appearances alone rarely provide reliable evidence. The strongest lesson from this hearing has little to do with the dollar amount and everything to do with timing. Once parties repeatedly confirm that a settlement is voluntary, reversing course becomes extraordinarily difficult. Family courts encourage negotiation because negotiated resolutions usually produce faster, cheaper, and more predictable outcomes than contested trials. That system only works if agreements carry real finality. This hearing shows why judges spend so much time confirming understanding before signing a judgment. The questions may seem repetitive to viewers, but each one strengthens the enforceability of the order. By the end, the court isn't rewarding one side or punishing the other. It's protecting the legitimacy of a decision both parties ultimately accepted.